Welcome to another production of Source Selection Soundbites. These productions foster learning, insight, and the ability to perform. Today's topic is an overview of FAR 16.5 Fair Opportunity Acquisitions. Today we will discuss the Federal Acquisition Streamlining Act, fair opportunity for task and delivery orders, and the limited protest jurisdiction of the courts. Multiple award contracts have become a popular procurement mechanism in government agencies, offering a flexible and efficient means to acquire a diverse range of goods and services. For government agencies, IDICs provide economies of scale, streamlined procurement processes, and cost efficiencies. These instruments were codified into law after the Acquisition Law Advisory Panel, in its 1993 report to Congress, concluded that many government requirements would be unnecessarily delayed unless agencies had the clear flexibility to enter into delivery order contracts for products and task order contracts for services. These contracts allowed detailed requirements, definite dollar value, and the timing of work to be accomplished by issuing orders as needs arise during the life of the contract. The panel recommended that task order and delivery order contracts be authorized by statute. Practically, these multiple award contracts allow the use of broad statements of work that generally describe the government's requirement for supplies or services. It authorizes the deletion of the public notice requirement when placing orders, limits protests in connection with the issuance of orders except on the grounds that the order increases the scope, period, or maximum value of the contract, and mandates that multiple awardees have a fair opportunity to be considered for orders in excess of the micro-purchase threshold. In terms of the fair opportunity to compete, once IDICs are established, fair opportunity to compete on task and delivery orders is required for all orders exceeding the micro-purchase threshold unless one of the following exceptions applies. Urgent needs due to unacceptable delay. Only one awardee is capable of providing the supplies or services, and a sole source logical follow-on contract issued in the interest of economy and efficiency. In continuance of the exceptions, the next exceptions are: when it necessary to place an order with a particular contractor in order to satisfy a minimum guarantee. A statute expressly authorizes or requires that the purchase be made from a specified source, and then there is the discretionary authority to set acquisitions aside in accordance with FAR 19 procedures. The general protest structure is that if the order exceeds a certain dollar value threshold, the GAO has exclusive jurisdiction over protest in connection with the issuance or proposed issuance of a task or delivery order under the Federal Acquisition Streamlining Act or FASA, with limited exceptions, such as when the task order increases the scope, period, or maximum value of the contract. The scope speaks to the types of work contemplated, the period of performance is the time period that orders may be issued, and the maximum value is the ceiling of the value of orders that can be issued. As long as the orders issued did not violate one of these three things, there is no judicial review of agency procurement decisions allowed. What these rules were believed to mean is that there could be no protests outside of the three aforementioned areas unless the value of the task order reached a particular threshold. For DoD, as of January 2025, the threshold is $35 million. For civilian agencies, the threshold is $10 million. In 2024, there was an adjustment to what the COF's jurisdiction was believed to be. In the court case Percipient AI versus the United States, decided by the U.S. Court of Appeals for the Federal Circuit, there are three additional areas of jurisdiction other than scope, period of performance, and ceiling violations. They include: 1. Violations of statutes or regulations in connection with task orders. 2. This ability to adjudicate the violation of statutes and regulations extends to all stages of task and delivery order competitions. And 3. They expanded the meaning of interested party in terms of the issuance of a task order. To wrap things up, let's review what we discussed. We discussed the Federal Acquisition Streamlining Act and its codifying of task and delivery order contracting. Second, we discussed fair opportunity to compete for contract holders. And third, we discussed the limited protest jurisdiction of the courts related to task and delivery order purchases. Thank you for watching another episode of source selection soundbites. For additional information, check out some of the other videos in this series, other productivity partners materials, or our source selection answer app that is available on the Google Play Store and Apple Store. In any event, thanks for watching, and see you next time.